10 or 15 years after a divorce settlement is finalized, a family lawyer might find this landing on their desk. Pensions are frequently the second most valuable asset in a marriage, trailing only the family home, yet they remain a source of significant mismanagement and financial remedies. The liability trap usually begins with offsetting. To avoid the complexity and delay of a formal valuation, a lawyer might suggest trading liquid capital in the family home for an illiquid retirement fund. This scale illustrates offsetting. It treats £300,000 in liquid capital as equivalent to a £300,000 defined benefit pension, but a pension is conditional. Subject to future income tax, inflation, and mortality risks, the math does not actually balance. Practitioners who rely on offsetting because they lack confidence with complex valuations create a potential opening for future professional negligence claims. The structural remedy to avoid this liability is Section 24B of the Matrimonial Causes Act, 1973, the Pension Sharing Order. Mastering the mechanics of a Section 24B order is a prerequisite for achieving equitable division and a necessary step for professional self-defense. The family court exercises absolute authority over the redistribution of matrimonial assets, and under Section 25 of the Matrimonial Causes Act, 1973, the court must consider all circumstances of the case to achieve a fair outcome. The specific statutory tripwire for pensions is found here in Section 25, subsection 2, paragraph H. The statute mandates that the court evaluate the value of any benefit a party will lose the chance of acquiring. A lawyer cannot ignore a pension simply because it is not currently in payment. It must pass through this statutory filter. The difficulty for many practitioners lies in identifying exactly what type of pension is being evaluated. There are two main categories. A defined contribution scheme is a visible pot of money based on contributions and investment performance. A defined benefit scheme is a promise of future income, fluctuating based on variables like age and market rates. Because of these variables, a defined benefit pension requires an independent actuary to value. A lawyer cannot reach an accurate figure with a quick calculation. Bypassing this expert valuation for the convenience of offsetting prejudices the client's final award and leaves the legal settlement vulnerable to challenge. Family law emphasizes the clean break, the objective of completely untethering two financial lives so each party can move forward independently. The Section 24B pension sharing order is the specific mechanism designed to achieve this clean break for retirement assets. The process begins by identifying the total pension fund as a single block. The court then mandates a precise percentage split based on equitable distribution. This generates two legal statuses. The original member suffers a pension debit, while the recipient gains a pension credit. This sharing order operates very differently from older pension attachment orders under Sections 25B and C. Attachment orders do not provide a clean break. They merely earmark funds, meaning the recipient remains tied to the ex-spouse's retirement age and faces a loss of benefits if the ex-spouse dies early. A Section 24B order avoids these risks. Once the pension credit is established, it is implemented in one of two ways. The first path is an internal transfer. The pension credit routes back into the original provider's scheme, forming a new independent account. The second path is an external transfer, moving the credit to a completely new financial institution chosen by the recipient. Section 24B is the more precise tool because it replaces an opaque, intertwined future benefit with a discrete, completely severed financial asset. Theoretical accuracy is only half the task. Practitioners must execute the split within the strict procedural framework of the family court. Even when parties agree on a consent order, pensions involve third-party stakeholders, the pension trustees, who must be managed under Part 9 of the Family Procedure Rules. The rules require notification using specific documentation, such as Form P, Part C, shown here. The administrators of the pension scheme must be formally served with this documentation, even before the court finalizes the order. The rules grant scheme administrators a 21-day objection period. This ensures the proposed split is compatible with the scheme's specific rules. While formal objections from trustees are rare, failing to provide this statutory notice is a procedural error that will prevent the order from being sealed. A perfectly calculated Section 24B split is ultimately ineffective if the practitioner fails to execute the notification procedures of FPR Part 9. The technical mechanics of pension sharing have significant human consequences. Compare these methods side by side. On the left, the fractured scale of offsetting. On the right, a balanced scale holding a Section 24B order and proportionate liquid capital. Data shows women face a higher risk of poorer old age when pension claims are mishandled during divorce. Research by the Pensions Advisory Group indicates that a lack of professional confidence contributes to pension orders appearing in only 14% of files. When lawyers default to offsetting to avoid complexity, they contribute to widening this wealth gap. Correcting this trend requires rigorous application of the statutory framework. The Section 24B order replaces an intertwined future benefit with a discrete, severable asset. It fulfills the statutory objective of a clean break while addressing the specific professional negligence risks inherent in unvalued settlements.